probably seen Deliveroo in the headlines and think that's gig economy stuff, that's a huge platform business, that's not really relevant to my business. But honestly, that's exactly where people get caught out. Because the real issue in the Deliveroo case that we're hearing about now isn't about food delivery. It's not bikes, it's not apps, it is something much more ordinary than that. It's this. What you call someone in your business and what they legally are not always the same thing. And if you're a business owner who works with freelancers, consultants, contractors, retained support, project-based hires, self-employed people, outsourced teams, or anyone who sits somewhere between a traditional employee role, this is one of those things that can quietly sit in the background looking fine until it really isn't. So in this video, I want to do 3 things. Firstly, I want to explain what the Deliveroo case actually decided, because a lot of people are oversimplifying it. Secondly, I want to explain why it even matters if you're nowhere near the gig economy. And thirdly, I want to give you a practical way to look at your own business and spot where the risk might be. Because this is one of those areas where the wrong assumption can become a very expensive one. So let's start with what the case was actually about. A lot of the commentary is reducing it to the court said Deliveroo riders are self-employed. That's broadly how people talk about it, but the actual legal issue was much more specific. The Independent Workers Union of Great Britain had been trying to get Deliveroo recognised for collective bargaining in respect of a group of riders. The litigation eventually reached the UK Supreme Court, which gave its judgment in November 2023. The question was whether the riders were in an employment relationship for the purposes of Article 11 of the European Convention on Human Rights, so that the union rights argument could succeed. The Supreme Court said no, and the reasons matter. The court focused heavily on the fact that riders had a broad right of substitution. In very plain English, that means that the riders could arrange for someone else to do the delivery work. The Supreme Court described that substitution right as virtually unfettered and said a broad power like that was inconsistent with a personal service you would normally expect in an employment relationship. It also mattered that riders could also work for competitors. They weren't required to work specific hours, and they weren't even required to carry out deliveries at all if they didn't want to. Those features pointed away from the kind of subordinate, controlled relationship the court was looking for if it was to be employment. This is why this case mattered so much, because it shows something that I say to my clients all the time. The label is not the whole story, the contract is not the whole story, and the working reality matters enormously. And there's another layer here that is worth understanding. Even though Deliveroo won in this UK Supreme Court in 2023, the wider legal and political direction across Europe has not been one clean march towards they are all self-employed. In October 2024, the EU adopted the Platform Work Directive, which is designed to make misclassification easier to challenge and to regulate things like algorithmic management more closely. Then in February 26, Reuters reported on judicial action in Italy involving Deliveroo's local operations over labour violations. So even if one company wins one case in one jurisdiction, the broader issue is still moving along. And that is why you should not look at the Deliveroo case lazily. You should never hear Deliveroo won and think, brilliant, I can call everyone self-employed and move on. That is not what this case gives you. Now let's bring this much closer to home. Most smaller businesses are not running an app platform, fine. But loads of smaller businesses do things like bring in someone 3 days a week and call them a consultant. They have a freelancer who has effectively become part of the team. They have someone that they've worked with on a self-employed basis for months or years. They rely on one contractor who only really works for them. They have a retained marketing person, operations person, an assistant, a developer, or a salesperson who is technically external but functionally embedded. That is where the Deliveroo conversation becomes useful. Because the real lesson is not what happened to riders, the real lesson is, have you actually looked honestly at how this relationship works in practice? That is the question. Not what do we call them, not what invoice do they send, not what did we put in a document 2 years ago. How does it actually work day to day? Who controls the work? Who decides when it is done? Can they genuinely send someone else? Can they work elsewhere? Are they part of your organisation in a practical sense? Are they economically dependent on you? Are they really running their own business, or are they functioning more as part of yours? That is where the real thinking has to happen. And the reason businesses get this wrong is not usually because they're being cynical, it's because they're busy. At the start, the arrangement feels practical, it feels flexible, it feels friendly. Everyone's getting on, nobody wants to overcomplicate it, nobody wants an awkward conversation, and everyone tells themselves they'll tidy it up later on. Those are the exact ingredients for trouble. So one of the biggest misconceptions in this area is the idea that self-employed status is basically a box you tick. It is not. Businesses sometimes think that if there isn't a contractor agreement and the person invoices them and there's no payroll, then that settles it, but it doesn't. Now, I want to be careful here because status questions are fact sensitive and I'm not giving you a one-size-fits-all answer. But what I can say confidently is this: a badly matched reality is where the risk lives. Because if your paperwork says one thing and your working arrangement says another, that gap is where the problems start. So let's take a few examples. Example 1, you have someone that you call a contractor. They only work for you, they work regular hours, you tell them what to prioritise. They attend your weekly team meetings, they use your systems. They are presented almost as part of the business. Now, does that automatically mean they're an employee? No. But does it mean you should stop kidding yourself that the label alone solves that issue? Absolutely. Example 2, you have someone who you describe as freelance, but they cannot realistically send a substitute. They cannot really turn work down, and the relationship has a steady, ongoing, integrated feel to it. Again, that's the sort of thing that should make you pause and think, because one of the reasons Deliveroo succeeded in that litigation was that the substitution right was broad, it was real, and it was very important to the court's analysis. If in your business, the supposed right of substitution is just words in a contract that nobody would ever actually use, that's a very different thing. And that is exactly why copying clauses from somewhere else is so dangerous. People borrowing language that sounds protective without asking whether it reflects reality. That is lazy drafting, and worse than that, it gives business owners a false sense of security. So what does the Deliveroo case not mean? This part is important. The Deliveroo decision does not mean that every business can safely structure work however it likes and just slap on a self-employed label. It doesn't mean that courts ignore the real facts. It doesn't mean that substitution language is magic, and it doesn't mean that the law has stood still. In fact, if anything, the opposite is now true. The EU's Platform Work Directive was adopted in 2024 specifically to make it easier to address misclassification and to impose more transparency around algorithmic management. That tells you the policy direction in Europe is still toward closer scrutiny, not less. And even in the UK context, the lesson from Deliveroo is about why Deliveroo succeeded in those facts. Broad substitution rights, ability to work for competitors, no obligation to work particular hours, no obligation even to accept jobs. Those features really, really mattered. So the practical question for your business is not, can I rely on the Deliveroo case? It is, do my facts actually look anything like the facts that helped Deliveroo? Because if they do not, casual name checking that case gets you nowhere. So what should you actually do with the information that I'm giving you here? Here is the practical framework that I would use. Start with honesty. Take the people in your business who sit outside standard employment and review them one by one. Ask yourself, what does the contract say? Then ask the more important question, what actually happens in real life? And do those two match? If the contract says they can send a substitute, has that ever happened? And would you genuinely allow it? If the contract says they're independent, are they actually operating independently? If the contract says there's flexibility, do they really have that flexibility? If the contract says they're running their own business, are they actually doing that, or are they effectively woven into yours? Then ask yourself a much more commercial question. If this relationship ended badly tomorrow, what would I be worried about? A complaint, a claim, a dispute over pay, a dispute over rights, tax problem, a messy internal situation, reputational fallout, because that usually helps business owners stop treating this as an abstract legal theory and start seeing it for what it actually is, a risk management issue. And then the final question, have we documented this properly in a way that reflects the actual relationship rather than some idealized version of it? Because that is the work. Not panic, not jargon, not pretending every contractor is really an employee. And not pretending a template solves everything, just clear-eyed assessment. So when you see a headline about Deliveroo and rider rights, here is the takeaway I want you to remember. This is not just a story about a giant platform company. It's a reminder that the law looks past labels. It's a reminder that the detail matters. It's a reminder that what seems flexible and convenient at the start can become messy later if nobody has properly thought it through. And this is where I think a lot of legal advice goes wrong. People either make it too technical or they make it too simplistic. They either terrify business owners or they wave things away. The useful middle ground is this. Understand what the case actually decided. Understand why it decided that. Then look honestly at your own facts, your own situation. Because if you are using contractors, freelancers, or consultants, the real question is not whether you have called them the right thing. It's whether your paperwork, your practice, and your commercial reality all line up. If they do, great. If they don't, that's exactly the sort of issue that is better dealt with early, calmly, and properly, rather than after a problem has already started. And that really is the whole point. Not to overcomplicate it, not to make you nervous for the sake of it, just to make sure that you are clear on where you actually started. If you work with freelancers, contractors, or consultants and you're not completely sure the legal setup matches the real working relationship, that is worth reviewing before it becomes a problem.